Hello, I am Jonah Markovic, and we will be talking about understanding waivers and informed consent in the fitness industry. So first off, just a little side topic. Right now I'm working at Movati, the newest one that opened up in Albany, and we do a lot of waivers, and I know the PC coaches or the PTs, whatever you want to call them, they also end up doing a lot of waivers and informed consent, especially when it comes to signing people on, setting up contracts, all that kind of stuff. But for me specifically, we deal with a lot of waivers. Whenever somebody comes in for the tour, we got to get them all checked in. We got to make sure they're all signed up correctly. When we get questions like, why am I signing this? We got to answer them clearly and correctly because we don't want to give any false information, especially on something like a waiver. So first off, what is a waiver? So a waiver is a document. It is a legally binding contract. So basically it's you kind of agreeing to some rules. It's the best way I can describe it. It waives clients' rights to sue for negligence. So there's a specific list of things that people have to follow, and whether they're followed correctly or they're not followed, then there's a little bit of leadway into some legal action that could possibly take place. It's pretty common in the fitness industry, especially for legal liabilities. That's definitely the biggest one. A lot of injuries, a lot of accidents, slips, things like that, for example. And it can create a negative image for your business slash brand. So depending on how keen you are on implementing these waivers, sometimes it can take away from the business. So you got to keep out for that. So why do we use a waiver? So it warns the client of inherent risks. So any sort of injuries that might happen, soreness, not using equipment correctly, things like that. It can reduce the likelihood of lawsuits. So, like we said, it kind of lists out a bunch of ways that basically the company covers their bum. It can provide legal protection if validated in court. So, if there was ever an issue and you did end up in court, as long as it's within that waiver that you have them signed, that's definitely a pretty important thing not to miss. And you must weigh the pros and the cons. So for this, you might need a little bit of legal advice, just to kind of justify it. And when it comes to something like a waiver and it comes to how much money that people might be suing for in the case that that happens, it's very, very important that you talk to a lawyer. So some of the arguments against waivers. So high cost and efforts to implement, especially if you're a smaller business and you don't really know where to start. Getting a lawyer, getting those fees, it can definitely be something to account for when it comes to starting a business. It may redirect resources from risk management and could be seen as unethical or illegal in certain cases. Um, it more depends on what's in the waiver, what you do and don't want. But yes, in some cases, it can be unethical or illegal. What makes the waiver valid? So clear wording is one of the biggest ones. So you have to, the person signing it has to understand what they're signing. That's the biggest thing. You can't use too many big words, and it has to have a flow to it, as well as it has to be easy to understand. Understanding the specific risks, so what kind of activities are happening that can cause injury, that can cause those things to be sued for. Scope of coverage, so obviously making sure you're working within the scope of practice, not doing anything outside. For example, something like as a personal trainer who just has their CSEP certification, you can't do 1RM training. You have to work within the 2 to 8 rep max training. So that's definitely something to keep out for. Making sure that you're staying within the CSEP scope is also very, very important. And then proper implementation. So making sure that the client understands what they're filling out, making sure that it's not too overcomplicated, and you need a signature for it. You need their signature, and I believe you also need the date. So here are some instances where a waiver might not be enough. So power imbalances, things like minors, if you have somebody under the age of 18, you need their parent to come in and sign for them. misrepresentation slash lack of clarity. So, like we said, if it's too wordy, it's too much to understand, that's definitely another really big factor. So, you got to make sure that it's nice, concise, and if somebody has a question, you need to be able to answer that question. Signing under pressure, I know this is a big one, especially for the memberships that I've noticed at Movati. Signing under pressure can be a little bit of a hiccup, but just you have to come off completely clear and you have to give 100% correct information. If you kind of stray away from the real answer, then that can definitely cause some conflict. And then injury from gross negligence, so things like you're working with a client and they say, I'm not feeling well, or they have an injury, but you're just kind of ignoring it, or they don't think that they can complete the exercise, and you're ignoring it and you're pushing them, pushing them, pushing them, then maybe you got to step back and take a look at what you're really doing for them. So the proper ways to implement the waiver, so you have to explain risks before presenting the waiver, so kind of give them a little rundown as to why they're signing the waiver and what kind of things are in the waiver that they're waiving, obviously. Give the client the time to read and ask questions. We want to make sure that they understand that they know what they're signing. Using a third party witness, obviously not a trainer or a client. So this can be potentially like a spouse, this can be another person at the facility, etc., etc. And then making sure that the form is signed and dated. We do need the signature, which is really important, but also when the signature was given is just as important. Because if somebody was to sign the waiver, but then they said, oh, I signed that many, many years ago, it's not valid anymore, then that is a case that they can sue for. So just a couple checklist things. So does it align with public policies? Is the language clear and specific? Does it disclaim negligence? Are there inherent risks clearly stated? And was the client pressured into it? So that's kind of the summary of the waivers that I would say. So are you following the policies? Is it easy to read? Were they pressured? Are all of the risks stated? And is there any sort of negligence that they need to know about? Finally, we're going to move on to informed consent. So the client has to acknowledge the inherent risks of the activities. So they're not necessarily selling their soul, but they're signing up and they're agreeing and saying like, yes, I understand that this is what I am doing, and if there is any form of injury, that they can go ahead and move on through it. More positive tone than waivers, yeah, it's not as enticing as waivers. It's not as much of a burden as waivers, where informed consent is just them saying like, yep, I'm okay to do exercise, I'm okay to follow the assessments, etc. It doesn't waive liability for negligence, and it encourages client understanding and questions. So yeah. The required elements of informed consent. So, what is the purpose of the service? What kind of procedures and assessments are being done? What are the potential benefits and risks? They have the right to stop at any time. There's also confidentiality assurance. So, when it comes to doing assessments, making sure that the trainer has a safe place where they're keeping everything and that it's not public knowledge, it has to be private. Only the trainer and the client should know the information. And then offer to answer questions. That seems pretty straightforward. If a client has a question about anything, you should be available to answer the questions. So now we're going to talk a little bit about informed consent in practice. So within the CSEP scope, so making sure that you're doing the CSEP assessments and training, making sure you're working within the proper scope. Everything must be signed, dated, and have a witness. You gotta ensure clients understand before proceeding, so that's kind of where we do a lot of desks and queuing, making sure that the client knows what we want from them during the activity. And another big thing is they can stop at any time if they feel uncomfortable. And the last one there, very, very important, make sure you're documenting everything. Because if you don't have something documented and they have the question and you say, oh, I don't know, then that can definitely raise some conflicts. So, in conclusion, the key takeaways, so waivers and consents are legal tools, not just paperwork, so they're very, very important. Proper use protects both trainers and clients, more on the trainer's end, but it can definitely also protect the client if there is any sort of injury. And then legal advice is essential for creating your own forms. So if you ever are unsure, like say you're starting your own small business and you're unsure about where to kind of go, make sure you get legal advice. That's definitely the most important, just to cover in case if there's any sort of suing or any sort of lawsuits like that. And finally, my resources. We're actually just going to go back